Calling the second case in our list, SJC-11449, K.G.M. Custom Homes, Inc. v. Stephen J. Prosky and others.
All right, good morning.
Good morning, Your Honors. Michelle O'Brien for the appellee and FAR applicant, K.G.M. Custom Homes, Inc. I wish to reserve 3 minutes for rebuttal. This case arises out of K.G.M.'s attempt to buy land from the Proskys to develop it for affordable housing. 5 years after the purchase and sale agreement was executed, and just as K.G.M. was settling disputes with the project opponents, the Proskys repudiated the agreement. And now, more than 9 years later, the parties have a dispute regarding the proper remedy for the Proskys' breach. The trial court committed no error in concluding that K.G.M. was entitled to money damages for the Proskys' breach of contract. At trial, K.G.M. established, and the trial judge found and ruled, that the Proskys breached the contract with K.G.M. for the sale of land. The breach initially was an anticipatory repudiation, but it was not a singular event that constituted the breach. It was a series of actions by the Proskys, as found by the trial judge, that culminated in their failure to convey the property at the closing.
There seems to be a dispute as to whether you actually raised the issue of damages at the trial level. I think the defendants say you didn't. It is the case, right, that both sides have switched positions completely. In other words, at trial, the Proskys were saying liquidated damages is all you get, and you were looking for specific performance, and now you're on opposite sides of that, right?
That's, I would say, partially correct, Justice Botsford, because it is true that the Proskys never asserted that K.G.M.'s remedy was limited to specific performance, and for that reason, I argue that they waived that argument because it was not preserved below. K.G.M., on the other hand, did assert in its verified complaint, which can be found in the appendix at pages 22 to 29, and specifically in its prayer for relief at appendix page 28, it requested specific performance or money damages. And as this court well knows, the rules of civil procedure allow a party to seek relief in the alternative or of several different types. It is true that K.G.M.'s position throughout the course of the proceedings was that it was requesting specific performance, but that was in large part because the Proskys were asserting from even before the commencement of the lawsuit that K.G.M. was limited by the liquidated damages provision in the agreement. And clearly, as the court well knows, specific performance is the exception to the rule. Where there's a breach of contract, the traditional remedy is money damages. But because land is considered to be unique, a party may seek specific performance, and of course they are alternate remedies. One cannot have both, as the trial judge correctly found and ruled in this case.
Now, you want the money damages, but you also want the attorney's fees incurred at trial.
That is true, Your Honor.
And now the judge said that the liquidated damage cause was essentially reliance damages.
Yes.
Do you agree with that?
Yes, in essence, it was a limitation of damages, not a true liquidated damages provision that really only allows K.G.M. to recover, as the language of the clause itself says, the costs incurred in connection with the transaction. And our position is that that extends through the litigation incurred in connection with the transaction.
Well, if it's reliance damages, though, I understand you would get the attorney's fees you incurred with regard to clearing the property with regard to the approvals below. But how would you get your attorney's fees at trial if it's reliance damages?
Well,
especially when essentially you lost at trial.
No, K.G.M. prevailed at trial and proved that
you wanted specific performance at $720,000.
Yes.
And the judge said, I'll give you it, but at the price the Proskys say was appropriate.
Correct.
And now you say, I don't want I don't want specific performance. I want the liquidated damages, which they essentially offered when they repudiated. So how do you call that a win?
Well, the Proskys now say that they, quote, offered to pay liquidated damages. I'm not sure factually that was precisely what happened. It's quite clear from the record that what really happened is the Prosky's attorney said that he had another offer for the property, and the Proskys were not going to go forward at the contract price. In fact, that attorney said he thought the land was worth $75,000 per unit. So as the trial judge noted in his decision, the Prosky's attorney wasn't trying to hold K.G.M. to what it believed was the correct price, but in fact was trying to extort an even higher price for the land at that point in
But
time.
wasn't the evidence that he also said, just tell me what the liquidated damages are and we'll get out of the deal? And
The evidence is that he did say, calculate your costs. I'm not sure, since neither of us was involved at that stage of the proceedings, I'm not sure precisely what the future communication was between counsel. But it's clear
Very
that
positive, one would assume, one would infer, not very positive, the
I
communication.
would certainly infer that, Your Honor, yes.
It's sort of the same question that Justice Gans is asking, but I looked at it a little bit differently. Given that the liquidated damages is part of the contract, wouldn't it be reasonable to assume that the attorney's fees that are mentioned there really aren't contemplating that you're going to have to litigate over this? It's really the cost of getting the cost that goes with getting all the permits and the approvals, et cetera, to develop the land.
The language says all, Your Honor, and I suggest that all means all costs incurred in connection with the transaction, and it just so happened, unfortunately for the parties, that the case went on and was litigated for many years. So I suggest that all in that provision means all costs. The case that the appeals court panel relied on, the Hermanson versus Savarowitz case from 2010 of this court,
I know that's a different matter.
It is a different matter, I would say, because there was no contract between the parties in that case. And here, clearly, there is a contract, and parties are typically held to the express terms of their contract. And I'd suggest that the attorney's fees associated with the litigation ought to be included as part of the attorney's fees and damages in this case.
Normally, in an action for specific performance, the plaintiff has to show that if they were the buyer, they have to show that they were ready, willing, and able to buy, and some kind of a tender has to be made. Here, there were things happened after the filing of the complaint, where at least where the judge found there was an actual breach as opposed to the anticipatory repudiation at the time of the filing. He found that both things had happened, that facts developed. I'd like to know what happened from the time of the time the complaint was filed up until the date of the closing, with respect to efforts that were made by your client and by the other side to make some kind of tender, or was that issue not even discussed?
I'm not sure the issue was discussed, Justice Spina. As I mentioned, I was not counsel to K.G.M. at the time.
But there's no pleading that seems to suggest that your client had to make a tender or a demand for a tender to be placed either in escrow or in a deposit with the court.
That is true, Your Honor. But there is one pleading that is located in addendum page 1 to my brief, which I think is relevant to this very issue of what communication took place. There was actually a default judgment on liability entered in favor of K.G.M., and the Proskys moved to remove that default as to liability. And in that pleading, which I'm trying to find my actual language, but essentially in that pleading, they admitted that they were not prepared to close under the terms of the contract. And the evidence demonstrates that Attorney
Just
Clark.
clarify, when you say under the terms of the contract, you mean under the terms as you define them, or which is the, I think that's what you're saying. You at the time were saying that it was less by about a third of the total cost, and they were saying it was $1,500,000. And I think that's what you're really saying, under the terms you thought were correct, which the judge later found was not correct.
Well, in fact, I'm talking about a pleading
Not, I mean
that
you, but you know, your client.
Yes, I understand, Your Honor. But in fact, the pleading that I'm referring to is a pleading that the Proskys submitted to the trial court, and the Proskys indicated that they were not prepared to close under the terms of the contract. It's not really clear from that what terms they're referring to. And in fact, the Prosky's breach discusses this dispute that arose with respect to the property to be conveyed and the purchase price for the property, and suggests that that dispute arose prior to the complaint having been filed. And that, as I understand it, particularly for my client, is not the case. And as the trial judge noted, the first time it became apparent that there was a dispute about the purchase price was when the complaint and the answer and counterclaim were filed. And then that dispute continued on. And it was clear from the actions of Attorney Clark before and at the purported closing on May 20th of 2005 that the Proskys had no intention to close on the property.
So you're saying that at the closing, there was no discussion of price? I know that there were blank terms, but there was no controversy as to price discussed?
There certainly was some controversy as to the correct purchase price for the property at the purported closing. I might note, though, going back to Justice Spina's question, that K.G.M. was excused from performance because of the anticipatory repudiation by the Proskys. And the cases, Tucker versus Connors, is quite clear that, and the trial judge found in this case that K.G.M. was excused from performance, but nonetheless.
But did the trial judge find that they were excused from performance by virtue of the anticipatory repudiation or by virtue of the breach when the judge found that the Prosky's attorney did everything he could to essentially scuttle the possibility of a closing?
My recollection is the trial judge found there was the breach at the time of the anticipatory repudiation. So the
It's really both. I mean, he sort of went on to get to
certainly,
the
as I
closing.
mentioned at the beginning, it's
But
almost
the
like
Tucker case seems to suggest that the question of the payment of the deposit has to arise out of some futility, that it would be absolutely futile to proceed. And that's not always true with an anticipatory repudiation, is it?
No, I agree with you, Your Honor, and I think that's part of the reason why K.G.M. attempted to go forward with the closing in May, by at that point having received all final permits and approval.
Well, I know that's an issue in the case, and that's why I was asking what the history of the litigation was in terms of any efforts by either side to compel or to offer to pay money into the court.
I would encourage the court to look at Attorney Souza's letter at page, I believe it's Appendix 284, which summarizes the proceedings at the closing and the actions of Attorney Clark at that time, and also Stephen Prosky's testimony. He was present for that purported closing. His testimony, I believe, is in transcript volume 6, which is quite telling as far as the course of events and indicating that the Proskys really had no intention of closing in May of 2005.
All right, we'll leave it there. You'll be back with your 3-minute rebuttal. Thank you.
Thank you, Your Honor.
Good morning, Your Honors. My name is Edmund Alcock. I represent the Proskys. With me is Haley Byron. Justice Spina, I'd like to start following up in response to your question. This case obviously was an anticipatory repudiation case because it was brought in December of '04.
Yeah, but it evolved. It morphed into something else, didn't it?
Understood. But I'd like to deal with first the anticipatory repudiation. Obviously, it was brought prior to any date being set for closing, December of '04. What happened between December of '04 and May, I believe it's May 20th of '05, is there were certain things that K.G.M. needed to do to actually trigger a closing. I believe there was a piece of a butter litigation that needed to be settled and some final permits that needed to come in from the DEP. So anything that happened any of the events that the trial court relied upon that happened prior to May 20th, 2005, we're all talking anticipatory pre-closing. And I think the law, if you look at the other 49 states that have adopted total damages or breach for an anticipatory repudiation, what the cases say, what the restatement says, is when you have an anticipatory repudiation, it excuses tender. It excuses performance. You don't have to go through the ceremonial closing. You don't have to hold the closing when there's been an anticipatory repudiation. However, they say that the obligations must remain performable. So in other words, the party must demonstrate, even though they don't go through the ceremony passing of papers, that they could have closed the transaction on the terms of the transaction. And we know here that they could not have closed on the terms of the transaction, on the terms found by the court, because they were never willing to pay $1.05 million
But they didn't have to pay $1.05 million. They only had to pay 1/3 of that, and then your clients were going to finance the balance.
But they also had to. That's right. They had to pay. They had to pay it was all configured in terms of what the purchase price was, and then they had to sign promissory notes, and they would not agree to $1.05 million as a total project, and they were insisting on another parcel of land.
And so what efforts did your clients make by way of a motion to compel tender?
They made no efforts.
So isn't the issue waived?
I don't believe the issue is waived, because I think the law says that they don't have to. Once there's an anticipatory repudiation, and we haven't disputed the trial court's finding in that regard, once that occurs, the tender is not required. So nobody has to tender, but it's still the obligation of the plaintiff to show that they were ready, willing, and able to perform on the terms of the contract. In fact, if you look at the restatement, I believe it's restatement 254, it says that a party's duty to pay damages for a total breach by repudiation is discharged if it appears after the breach that there would have been a total failure by the injured party to perform his return promise. And that's what occurred here. The K.G.M. was never, not on the date they filed suit, not at the date of closing, not through the date of trial many years after. They were never willing to perform their return process, to perform their return promise. Even at the closing, the May 20th, 2005 closing, which the trial court found the Prosky's then counsel, and again, I wasn't counsel at this, penchant for taking a video camera to the closing somehow constituted a breach. If you look at the trial testimony of the closing attorney, he indicates that the reason that the transaction did not close on that date, on May 20th of 2005, is because there was a fundamental disagreement as to the terms of the purchase, i.e. 720 versus 1,050, and what lot of land was to be included.
So the amount of the tender itself was in dispute?
Correct.
And was any effort made to compel them to put even the minimum amount, the minimum possible amount of tender?
I don't think there was any effort made, Your Honor, because quite frankly, there was a declaratory judgment action pending in the Bristol Superior Court as to what the amount was supposed to be, as to what the amount of the transaction was supposed to be, and as to what the Stormo, whether the Stormo land was included. Quite frankly, the parties are in litigation, and the Prosky's attorney get a letter on May 13th saying, hey, there's a closing in 7 days. So the Prosky's attorney showed up, and he showed up with his video camera, and you know, as you can see from the, and then, you know, counsel engaged.
So what are we to make of circumstances where not only is the amount of the contract price in dispute, but the amount of the tender is necessarily in dispute as well, and there's no effort made by the Proskys here to compel them to make a tender even at 1/3 of $720,000.
Well, I don't think, again, I just go back to saying that if you follow the law of anticipatory repudiation, and again, it's a little odd because in Massachusetts, it's only recognized for a specific performance, but if you follow the other 49 states, I think it just says it's excused. It's excused.
So you think there was an anticipatory repudiation by them? I mean, in substance?
Well, I think, again, I have to stick with the trial court's finding. I think the trial court said that the Proskys anticipatorily repudiated, which obviates the quote-unquote ceremonial closing, and then...
But your theory, your resulting theory in making that statement is that they couldn't seek damages.
Correct.
That's really why you're making the statement you just made.
Correct. They couldn't, and I think that's, and I think there's some reason for that in Massachusetts. I think the reason Massachusetts hasn't adopted the position of the other 49 is they say land is unique, and we don't want to have this. What do you do in the meantime if there is going to be a closing? Who does what?
But here we have circumstances that changed while the litigation was pending. That change was actually litigated, or the evidence surrounding that change was litigated. The judge concluded that not only was there an anticipatory repudiation, but there was an actual breach. So no effort was made to get them to compel to get the K.G.M. to make payment of any amount of money into court.
Well, I think the reason that effort wasn't made is because the Proskys were arguing to the court that there was no breach because they weren't obligated to pay to accept $720,000 for their property and to convey a piece of land which was not included in the P&S. I think the litigation tact was there is no breach, anticipatory or otherwise. We don't have to convey our land for a price that's not stated in the P&S, and we don't have to convey a parcel of land that is not included within the P&S. I think that's why the litigation, the litigation went the way it did. And with respect to the finding of an actual breach, I think the trial court's conclusion in that regard was erroneous. They found, basically the trial judge disregarded the testimony of closing counsel who said the reason it didn't close is because there's a fundamental disagreement as to the purchase price and the land to be included, and instead, I think, was more enamored with the fact that there were shenanigans going on in the closing room with a video camera and shutting off the electricity and all of that,
and not letting K.G.M.'s counsel see the closing documents.
Yes, that's right, holding him up to his face, but even K.G.M.'s closing attorney himself, to his credit, testified at trial that the reason it did not close was, and he also did it in a letter that he sent out the day after the trial, both of which are in evidence, indicating that the reason it didn't close was because there was a fundamental disagreement as to the purchase price and the land to be included in the transaction, not because somebody brought a video camera to the closing. So,
but what the closing attorney sent a letter saying we've got an offer from somebody else. We're out of here.
correct.
So
Correct.
at that point, you're saying that when they're supposed to invest money in getting permits, and you say there was still some work left to be done. So your argument is that when you say to them, we're out of here, we got a much better offer, we're not selling to you, they don't get any damages unless they continue to invest money in completing their permitting process so that they can go to a closing and say, even though you've said we're out of here, we're still spending money to close a deal which you've rejected?
Your Honor, with all due respect, the letter that was sent by the Prosky's attorney was, or the communication was back in August or September of '04, prior to the institution of the suit, and well in advance of the closing. What I suggest that...
So why does that matter?
Well,
I mean, did he ever say, never mind? I was drunk when I sent that letter?
No, Your Honor. What I suggest occurred there, and it's why I haven't challenged the trial court's finding, is when that occurred, there was actually an anticipatory repudiation. That's fine. And I acknowledge that. The question is, what is the consequence of that anticipatory repudiation going forward? And what the law says, what the restatement says, is, and again, let's not kid ourselves. The reason for all of this, what was festering at the time, was the dispute of the purchase price, the 32 lots versus the 41 lots. That had always been simmering, and quite frankly, in my opinion, was the reason for the lash out by my predecessor counsel.
But get to the point. So he sends this letter,
but my
and that's
point-
anticipatory repudiation, and as a result, what, if any, damages are appropriate?
Well, in Massachusetts, we know the answer is none. We know the answer in Massachusetts, unless they adopt the view of the restatement and the other 49 states, we know that it's not available.
But you say that to some degree, or maybe completely, because there's been no amendment, no attempt by K.G.M. to amend its complaint to conform to the evidence that was adduced at trial. So if we were to say now, remand it and give the K.G.M. leave to amend its complaint, how have you been prejudiced?
I don't say it entirely because of the fact that they proceeded for 5 years on a specific performance theory, and then the judge.
But the facts were
took it
fully
away.
litigated. I mean, the question of
I
what
agree.
took place at the closing, everything was out there.
I agree, Your Honor. And I guess what I'm saying, again, is I go back to, in Massachusetts currently, where the breach is anticipatory in nature, money damages cannot flow from it. That's what the state of the law is in Massachusetts. What I'm saying is, in the other 49 states, I think we wind up at the same result, even if this court decides we're going to adopt the view of the other 50 states, because the sequencing is as follows. Anticipatory repudiation occurs, performance is excused, and it's still the plaintiff's burden at that point in time, if they want to get money damages, total damages for the anticipatory breach, to show that they were always willing to perform the obligation. And we know here that they were never willing to perform the obligation.
Even if you have a liquidated damages clause in the contract?
Yes. Yes, well, Your Honor, I think that might have been different if at the outset, in an anticipatory repudiation state, they said there's been an anticipatory repudiation and we want to seek liquidated damages as a result of that, but they'd still have to prove that that the obligation in the contract was performable by them. That's what the
So
restatement
you're saying that
forbid say.
back to Justice Gantz's question then, they've got to spend all that money to get the rest of the permits in order to show that they...
No. What they have to show is they were ready, willing, and able to buy on the terms contained in the contract, which is $1,050,000, no storm or lot. They can't benefit by their willingness to breach the contract out of the gate. Okay, I mean, I understand what the Prosky's prior attorney did was incorrect. It was wrong. It resulted in an anticipatory repudiation. But the fact of the matter is, they were never going to perform on the terms of the contract themselves.
But the terms of the contract weren't identified until the judgment issued.
Your Honor, I would disagree.
There was an ambiguity as to the price.
I would disagree. I would say the terms of the contract are always the terms of the contract. They are in there. Now, in this case...
Well, and they're ambiguous.
Well-
And what the meaning of those terms are wasn't ascertainable until the judgment entered.
I would disagree. I think in this case, people wound up seeking a declaratory judgment. I think the meaning of the terms are and always were in the contract. The fact that a judge had to ultimately decide what the contract said 5 years down the road doesn't obviate what was in the contract from day one. I mean, the fact that there was an interpretive...
You're going to have to wrap it up, Mr. Elcock.
Okay, Your Honor, the one last thing, I don't believe there's been any waiver in this case because from day one in the litigation, the trial court, the Proskys consistently argued that there was no breach. And I know my sister referenced a pleading where there was something that was admitted. Quite frankly, it was a typo.
It says defendants were not prepared to act in accordance with the agreement. That's a typo?
Yes, it was, because Your Honor, if you read the prior sentence, it says, and this is submitted by the defendant's, the prosecutor's attorney to vacate a default judgment. The prior sentence says, defendants attended a closing scheduled by plaintiff on May 20th, 2005, prepared to negotiate the issues left unresolved in the purchase and sale agreement and ultimately perform.
And then it says defendants were not prepared to act in accordance with
Yes,
the agreement.
it's a typo.
Thereafter, plaintiff commenced the present action.
It's a typo.
Well, that doesn't necessarily follow that that's a typo.
It does, Your Honor, because the preceding sentence, it says defendants attended a closing intending to resolve the
Negotiate.
issues unresolved.
Right. So then there was something unresolved
But
in their minds.
understood, Your Honor. But I submit it wouldn't make sense. It doesn't make sense for it to say the defendants, we're trying to vacate a default. It doesn't make sense for the defendant's counsel to say, we weren't prepared to perform in accordance with the agreement, and we want to vacate the default so we can argue that we were there intending to perform in accordance with the agreement. It's a typo. They use defendant instead of plaintiff.
Let's leave it there.
Thank you, Your Honor.
Thank you.
There's a lot I would love to respond to, but I only reserve 3 minutes. That is the first I've heard that language is a typo. That was not ever raised in any of the post-trial proceedings, as I recall. And there were many post-trial motions submitted by the Proskys, each of which was denied. But let me just address a few things, if I may, in the short time that I reserved. If a buyer's remedy for for a seller's anticipatory repudiation of a contract to sell land is limited to specific performance, there's actually an incentive for seller to anticipatorily repudiate a contract. A seller, like the seller here, who thinks he can get a better deal, is actually encouraged, in some respects, to anticipatorily repudiate the contract and try to negotiate a higher purchase price. Because the worst that could happen is the seller has to sell for the terms of the contract. Meanwhile, the buyer would have incurred additional costs, time, money, and that would be not only unfair to the buyer, but in fact could reward the seller, even though the seller has breached the contract.
But doesn't that argument depend upon market conditions? If the price of the land goes up, all you have to, if it goes up in value, all you have to do is pay the contract price, and in the meantime, you've had an interest-free loan for a period of a couple of years. If the arrow goes in the other direction, you're hurt for just the opposite reason.
That may be true, Justice Spina, and in this case, I would suggest that K.G.M.'s remedy, if it is limited to specific performance, would be an injustice to K.G.M. because we're now, I believe.
So are you saying that under a theory of damages, change in market price is something that should also be part of the litigation?
No, but I'm suggesting, Your Honor, that this court ought to adopt the doctrine of anticipatory repudiation for all purposes. But whether or not the court does so, in this case, K.G.M. is entitled to money damages. Because first, the Proskys never argued in the Superior Court that K.G.M. was limited to specific performance, so therefore they waived that argument. But perhaps more importantly, although K.G.M. brought its action before the time for performance, K.G.M. alleged and ultimately proved that the Proskys actually breached the contract for the sale of land and the covenant of good faith and fair dealing.
Under the current state of Massachusetts law, is that the reason you're entitled to monetary damages, that it was litigated and the judge found there was an actual breach of the contract?
Yes, that is certainly one reason, because the doctrine or the exceptions to the doctrine, if you will, or the exceptions to the Daniels rule in Massachusetts do allow for money damages where there has been an actual breach in addition to the anticipatory breach of the contract. And I would suggest that the appeals court case in Kavanaugh, which this court denied further appellate review on from 1992, I recall, is instructive because in that case it's similar, but the facts are almost the reverse, where there was as I recall, there was no request for specific performance. It was actually an action seeking money damages. But the court, the appeals court, reversed the Superior Court's dismissal of the case, allowed it to go forward, even though there was, in essence, an anticipatory repudiation and the plaintiff was seeking money damages.
Ms. O'Brien, your time is up.
Yes, Your Honor. Thank you very much.